The publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews would only increase the concerns that the defense has.
Bryan Kohberger's lawyers pushing back against the media's request to lift an order barring the state and the defense from talking about the case and releasing records about the investigation into the murders on King Road.
The media frenzy, as it has been described, will continue regardless.
Welcome to Crime Fix. I'm Angenette Levy. Since Bryan Kohberger's arrest for the murders of 4 University of Idaho students in late December of 2022, we've had so many questions for police and prosecutors about the case, and they've not been willing to answer any of them because they agreed to a non-dissemination order, a gag order, if you will, proposed by Kohberger's defense team. Now, that agreement, it barred the release of any information or public statements about the case that didn't come from court documents, but now Kohberger has pleaded guilty. He's admitted that he broke into the house on King Road around 4 a.m. on November 13th, 2022, and stabbed to death 4 people that he didn't know. And from what prosecutors have said, had absolutely no relationship to whatsoever. Kohberger stood up a few weeks ago in open court and admitted to stabbing Maddie Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. All were killed within a matter of minutes. At the end of the plea hearing, Judge Hippler proposed lifting that non-dissemination order.
Any reason why I should not rescind the non-dissemination order at this time?
Your Honor, I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through sentencing.
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point.
So after that, the Media Coalition, which Law&Crime is a part of, filed a motion asking for a hearing and requesting that the non-dissemination order be lifted. The coalition's attorneys wrote, Mr. Kohberger's plea sharply changed the Sixth Amendment fair trial / First Amendment balance in this case. Mr. Kohberger will never face a jury to determine his guilt, nor will a jury have any role in determining whether the death penalty is the proper punishment. All that remains is for the court, not a jury, to impose a sentence. But even then, the parties have waived a pre-sentence investigation, and Mr. Kohberger has agreed that he will not argue for anything less than consecutive life sentences without the possibility of parole. Now, Prosecutor Bill Thompson, he has since changed his mind about the non-dissemination order, and he filed a response saying he agrees that the order is no longer needed, but he said he will not be making any public statements until after sentencing. But Kohberger's lawyer, Ann Taylor, she wants that order to remain in place until sentencing. Taylor wrote, the revised order recognized that Mr. Kohberger's rights extend beyond the question of guilt or innocence to his right to a fair sentencing proceeding, regardless of whether the proceeding is reached via a jury verdict or a plea. So our content really shows you how important personal safety is, and that's especially true when it comes to protecting your privacy online. You would be shocked at how much of your personal information is out there, like your address and phone number. Ever wonder why you get so many spam calls and emails? That's because this information, it's all public. That's where our sponsor Incogni comes in. It's a service that helps you take control of your online privacy by removing your personal data from data brokers. Those are huge companies that sell and trade your info without your permission. Incogni actually found more than 50 brokers with my information, and here's the kicker. These data brokers have to remove you from their database if you ask them to. Now you're probably thinking, Angenette, who in the heck has time to contact a data broker? Well, that again is where Incogni comes in. They contact those companies for you to get your online safety back. You don't have to do a thing, and then they alert you after the request has been completed. After signing up, I get virtually no spam now, so I highly recommend giving Incogni a try. Right now, anyone who uses the code CRIMEFIX at incogni.com/crimefix gets 60% off. That's code CRIMEFIX at incogni.com/crimefix for 60% off an annual Incogni plan. Taylor also wrote that threats have been made against Bryan Kohberger and others, and releasing information could make it worse. Taylor wrote, further release would only serve to gin up the anger and violent rhetoric already at a fever pitch. Again, this court is well aware of the threats posed not only to Mr. Kohberger, but to his family and to court staff. Taylor also brought up concerns over courthouse security. She wrote, court security resources were at maximum capacity on July 2nd, 2025. The sentencing hearing, scheduled for 2 days, promises to be even more taxing on those resources. Lifting the non-dissemination order now is likely to change the atmosphere near the courthouse and may well push security needs beyond capacity. And there are portions of Taylor's response that are redacted that appear to address the leak to dateline and an investigation into who leaked that material about Kohberger to NBC. So let's take a look at the arguments from the hearing.
Ms. Olson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court. And given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Now, I'm going to tell you something. The defense, they really knew they were fighting an uphill battle here, but they were asked whether they had anything to add in addition to the documents they had filed.
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
And really the entire time, Bryan Kohberger, he was attending this Zoom hearing from his jail cell. You could see him up there in the corner wearing the jail jumpsuit. And you could see him kind of making some faces, but he may be expected to lose this. Judge Hippler said that he actually had anticipated a motion from someone to vacate this non-dissemination order. So take a listen.
Frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated that they don't intend to until after the sentencing. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order.
So I want to bring in Jack Reiner. He is a First Amendment attorney based in Cincinnati, Ohio. He's fought a lot of these battles. I've fought a couple of them with him, and we've won. He is with the Faruqi law firm. Jack, your response to the defense wanting to keep this gag order in place until sentencing?
Well, I think that it seemed to me to be kind of a half-hearted effort on their part. There's very little case law cited. There's very little justification for it. The best they can seem to be able to come up with is that, Mr. Kohberger will be in danger because the public will get stirred up if they get access to the prior proceedings in the case. And I'm not aware of much precedent that would support that. This case was originally, the gag order was put in place to protect his fair trial rights and to avoid tainting the jury pool. And now that he's, pled and the judge will be doing the sentencing, the judge has presumably seen all of this stuff. So it's not like the gag order is prohibiting the judge from seeing this information. There's really no reason for it. And the idea that a person who's pled guilty to brutal murders of 4 people might be in some sort of danger. Well, yeah, they might. But I don't mean to make light of it. But the idea that that gives him some sort of they're almost arguing that he has a privacy right, which I think is just absurd. He's a public figure. He's admitted to brutal crimes. And the notion that he has some sort of right to privacy that would preclude a court from releasing public information to the public, I think is just a very weak argument.
Judge Hippler, in this case, has really erred on the side of the public and the public's right to know,
Right.
which I've really found very refreshing because in this case, both sides were filing a lot of stuff under seal. And he came out at one point and he said, hey, knock it off. If redact stuff, if you think it needs to be redacted, but you need to err on the side of having things be public. And so I appreciated that. And so they started redacting things instead of just filing everything under seal.
Yeah.
And so he was loath to keep this thing in place during the plea hearing. He suggested lifting it and he wanted to lift it and he let them, have some time. And I've seen cases, I've covered cases where a gag order remained in place until after sentencing. Typically, though, that happens when, a trial had been had.
Right.
And who knows why people want to do that? Maybe they just don't want to deal with the press. But Judge Hippler said during the hearing where he lifted the gag order, I was inclined to lift it, but I gave you guys some time and I anticipated a motion and I thought a motion would be coming to vacate this. And he said the public has a right to know.
Sure.
So I found that really refreshing.
Yeah, well, I think when there's a trial, there is a public airing of the material. I mean, it's very, 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 very rare to keep the public out of a trial, right? So when there's a trial, the public is going to get information about the case. They're going to see evidence, and exhibits and that sort of thing. So I think when there's a plea and there's not a trial, to keep the gag order in place just really increases the harm to public transparency, because there's not the public airing that would take place in a trial. And so, the public's inability to get this information while it's fresh, while it's still newsworthy, is really problematic. And I think that the idea of a defendant getting an unfair trial because there's a lot of pretrial publicity is generally overblown. And most of the time, the defense, when they move for that, have a hard time justifying it when they're pressed to present some evidence that it's going to unfairly taint the jury pool. And the Supreme Court, the United States Supreme Court has said that before you issue a gag order, you've got to do other things like a very detailed voir dire of the jurors. To find 12 jurors who have not kept up with the news, not that hard, really. I mean, we seem to think, you and I, we're on top of a case like this, but the average person in the public who's just trying to get through life and work and pay bills really isn't, that steeped in it. So you've got that. You've got the possibility of a change of venue. You can sequester the jurors to make sure they don't receive information about the case. So, and you have to do that. I mean, the Supreme Court has said you have to go through those steps before you can prohibit or you can issue a gag order. So, in my experience, jurors you can find 12 jurors that don't know much about the case, even a highly publicized case. I really believe that. Yeah.
But the thing about this case, Jack, was that the gag order, the non-dissemination order is what they really call it, was issued immediately, pretty much immediately after the arrest of Bryan Kohberger. The defense asked for it pretty much immediately, and the state agreed to it. And so that was before, any voir dire took place or anything like that. So this thing has been in effect. Essentially, there was a revised, amended non-dissemination order, I think, that went into effect in June of 2023. But this thing has essentially been in effect since January of 2023. That's a really long time.
But it's a long time, and that's essentially a news blackout for that. And I just think that, when you have the other just from a policy perspective, when you've got a very high profile case like this, when you issue a gag order, what you're doing is sequestering the facts, really. And so you create this vacuum, and what fills that vacuum is speculation and gossip, and it's worse. I think it would be better to have accurate information out there, because if you don't, it's going to get talked about. But the talk is going to be uninformed and speculative and gossipy, and I think that's worse.
Yeah, it is much worse, and I think that they saw that in this case, in the very beginning. The first 3 days, after the homicides, there was no really word from the Moscow Police Department, and that did allow a lot of rumors to circulate. They came out, 3 days after the homicides and had a press conference, but the genie was out of the bottle as far as rumors and stuff go. So I think that these things in some ways can have unintended consequences and do more harm than good. One thing that I found interesting, too, is that Judge Hippler basically said, too, that he will be unsealing records. He's not going to do it immediately as far as court records go, but he is going to do it. He'll have to review those. He will do that. But, he's going to start with the newest ones because he's most familiar with those, and then work his way back. So it's not going to be an immediate kind of mass unsealing because he has to review this stuff, but he has to do it after sentencing.
Right. Well, he sounds like a pretty thoughtful judge, and hopefully, we'll get the right decision ultimately here. But it has obviously been delayed, which is unfortunate. So any further delay is not a good thing, and hopefully, we'll get to maybe get some. I'm sure there'll be some interesting information that comes out.
Is it possible, too, that, I was talking to someone last night who we were kind of going back and forth when we were reading the defense's opposition to lifting the gag order. And we were thinking to ourselves, this case, the brutality of it is just so, it's beyond the pale. Is it possible the defense knows it's worse than anybody really thinks, and they just want to delay as long as possible the facts, maybe some of the details getting out, because they're concerned. They're concerned about possibly things getting out before sentencing and this mass gathering at the courthouse.
Yeah. There's already been leaks, apparently, that the judge mentioned, or that was mentioned in the motions. And there's obviously a lot of high interest. James Patterson has some interest in this case, and I think Amazon was doing a show about it. As I say, I think that the defense had an uphill battle to try to keep the non-dissemination order in place. I don't think their effort was all that stellar, but I just don't think they had much of a hand to play, really, at this point. And certainly when the state said, yeah, we're fine with lifting the dissemination order, that was problematic for them. If the state had held to their position, I think they'd be in a better spot.
Yeah, they likely would. But again, this is a judge who's erred on the side of transparency, on the side of making things public. And he's been very no nonsense. And so, a big loss for Bryan Kohberger, but probably not an unexpected one. And we will watch as the sentencing occurs next week. Jack Greiner, First Amendment attorney with Faruqi Law, thank you so much.
Okay. My pleasure, Angenette. Thank you.
So there you have it. That non-dissemination order is no longer in place. And Bryan Kohberger, he will be sentenced on July 23rd, and Law&Crime will be there at the courthouse in Ada County. That's in Boise, Idaho. I'm Angenette Levy. I will see you here next time. Thanks so much for joining us for this episode of Crime Fix.